Favourite drinker.
Guys.
Yeah.
Hello.
Anton. Hi. Yeah. What about you, Nigel? What about you, Nigel?
I'm also a lawyer. Sorry, your camera's off.
Okay. Okay.
Yeah, I'm good. Thanks.
Yep.
Yes, can you hear me? Awesome. Hi, everyone. Hope you're having a good Friday. I'm Ishita Luthra, senior lawyer with Sprint Law UK. Sprint Law is an online firm advising early stage small and medium businesses with their legals, right from setting up to formalizing your business contracts, platform T's and C's to fundraising, registering your trademarks, privacy policies, and all of that. We won a bunch of industry awards for legal innovation last year, and we've also launched our in-house AI lawyer. I've also written a book called The Inner Circuit, helping founders and busy professionals get some peace and clarity without the need for therapy. I'm happy to be here and looking forward to having a great chat. Over to you, Richard.
I think it was Richard before me, but
Okay, I'll go. Yeah, thanks, Nigel. Yeah, my name's Richard Hall. I'm a partner in the US firm Fagerl Drinker Biddle and Reef. I am in the London office of that firm. My specialisms are corporate transactions in the financial services sector and financial services regulatory.
okay, so is that me next?
There's Nigel,
So-
I think.
Okay, I'm Nigel Brahms. I'm a partner at a UK law firm called Collier Bristow. We are based near St Paul's. My personal experience, well, as a firm, we cover a wide range of business and personal services. Personally, my expertise is in financial services regulation and early stage investment, particularly in the fintech and financial services sector, also a specialization in crypto.
In London at a UK US law firm called Haynes Boone. We're headquartered actually in Dallas, Texas, with 19 offices out in the US and across the UK and other parts of the world, including Asia and South America. In London, my focus and our group's focus is on the venture capital growth side of things. A lot of work working with startups and emerging companies as they are looking to grow and scale their businesses. We also work with UK European businesses as they look to scale into North America as well. And then the other piece that we also cover is on the investor side, lots of work on the fund formation structuring side of things as well. Thank you.
Wow, that is amazing. Thank you very much to all four of you. I really appreciate your time today. Well, you've heard them, people. We've got four brilliant lawyers with us today, and they're going to be here with us for the next 15 minutes. Now, as they prepare to think of some of one do and one don't each, just a quick reminder to those of you that are on the live streams, whether that's LinkedIn, YouTube, Facebook, or Instagram. And by the way, team, if you don't mind muting if you're not talking because it creates an echo, we'd appreciate that. So just a quick reminder to those of you that are on the live streams, whether it's LinkedIn, YouTube, Facebook, or Instagram, please be aware that we are unable to monitor your questions live there. Whilst we're thankful that you've joined us, I think you would be much better off joining us here on Microsoft Teams Live. It's audio only, which means you can join from anywhere via any device or platform. And the quickest way to do that is to go to our website, startuptoscaleup.club. You find today's session, which is Startup Legal Q&A 06. You click join. It's a quick registration. That gets you a link to your email, and through that link, you can join us. Once you're here, all you have to do is simply drop your question in the chat. We'll give you the mic, and then you'll be able to ask the lawyers. Basically, we're taking any questions to do with your early stage and startup law, basically anything to do with your company and whatever you're trying to navigate in terms of UK law. So just UK law today. And we're going to do that until 1 p.m. Now, if your questions are on other matters, please save them for the other events. We run 6 regular events: Monday Style and Tuesdays Product and Tech, Wednesdays Growth, Thursdays Fundraising, second Friday of each month. As you can see today, it's Startup Legal, and third Friday of each month it's Startup Finances. So without further ado, perhaps we can start again with Ishita, and then we'll swap it a little bit. But since you've been here before, Ishita, if we can have one do and one don't when it comes to early stage legalities, we'd really appreciate it. And then perhaps we can swap it a little bit. We can start with Andrew, then Nigel, and then Richard.
Sure. So my first do would be, if you're a founder and you are engaging people to, say, develop tech or create product for your business, and they come in, asking, for shares in the company in exchange for being paid by salary or commissions, etc., because generally startups don't have enough funds to kind of give away salaries. So if you're promising shares, rather than having a handshake agreement, I suggest you should formalize that in a written contract, because often founders come to me and say, this is what I've promised, but I've not received my funding, so the shares were to vest in the event when the company receives its first funding. Sometimes, and this is something that Anton mentions regularly, that 95% of the startups fail. So in case you're not able to obtain funding and you've promised shares on occurrence of a funding event, then in that case, you need to have specific clauses in your contract with the tech person or the product person that you've engaged to set out what happens if the company doesn't receive funding, or if that event doesn't take place, and if they're not allocated shares. So short point, that you should formalize your contracts with your co-founders, your technical people that you're bringing in, and set out clearly what those terms of engagement are. In terms of don'ts, I would suggest that as a founder, don't give away excessive equity from the start, because equity, is in essence means your control in the company, because shares carry voting rights, dividend rights, etc. And you need to, if you're looking for investment, you need to make sure that you have enough to kind of govern the decision making. If there's an investor on board, or if there are other employees on board, what does your cap table look like? So yeah, shares equal control. So don't give away too much control from the beginning. Yeah, those are the 2 points.
Thanks, Ishita. I think it was me next. Was it Andrew next? Yep. Yeah, so actually, I think one point that just to slightly link to what Ishita was saying around the shares and dilution, I guess the one key point on the do side is planning. And what I mean by that in terms of planning is thinking, even if you're really at a super early stage, about having your investor deck in place, your business plan, any modeling that you're looking to do in terms of how you're looking to build, develop the product, etc. And try and do as much as that up front. Of course, things will change, everything does in startup world, but if you show some discipline early on and really think hard about where you might see things in 3-5 years time, that will really help you to sort of structure or figure out what your roadmap and development is, and it will also help you figure out what your financing needs are, to what extent you need to go to external financing. And when you do that, you should also be preparing things like a cap table with different modeling scenarios about, do you take some angel funding in first, how much equity to give away in inverted commas or dilute early on, and I would try and go your early stage to the seed, maybe even to Series A and even beyond, so you can always work backwards, because one of the problems that some startups have is they get a quote unquote broken cap table, where if they do give away too much equity, not just about control but just pure on economic alignment, you then get yourself to late seed or Series A, and you get an institutional investor coming in and they like what you do, but they look at the cap table and think this isn't investable, because the founders haven't got enough equity in the business to sort of make them fully aligned and incentivized to really crack on with the business. All of those things can be dealt with and can be sort of resurrected, but it can get messy. So that's sort of one point around the whole planning. In terms of a don't, broken cap table in inverted commas is one to obviously to avoid, as mentioned. The other thing as well is that, particularly the early stage, when you're looking to take in investment, I just really encourage you, if you're on the startup side, to think very carefully about who you take your money from as well, and also on what terms, because it can be very easy to get a bit starry-eyed and seduced by people coming in and offering financing, and also potentially a really exciting valuation, which can come with its own problems as well. So really think about who you're taking the money in for. Are you wanting them for strategic value add, or are you just wanting someone a bit more passive who's going to be supportive and not sort of cause you any particular trouble? And just as those investors may well ask a load of questions of you about your business, you shouldn't be shy in understanding what those investors, who those investors are and where they've invested. Do they follow on their investment? Getting a reference check about other startups they've invested into. So I think that's the other aspect. Thank you.
I think it's me next, Nigel here. I was going to talk a little bit, again, a bit about shareholders, but I'm going to talk about shareholders agreements. My first is actually going to be a don't. Don't draft your own shareholders agreement. You're better off not having a shareholders agreement at all than drafting your own one and making mistakes in it. And I've seen this from a client side, where a client had drafted their own shareholders agreement and the shareholders agreement was inconsistent in various very important respects. And in one particular respect, it had 2 different clauses talking about amendments to the agreement. What they'd clearly done is they cobbled together an agreement based on two other agreements they'd seen, and it was a DIY job, and it left them in a complete mess. And then when the shareholders fell out, which very often happens, they were not in a position to agree anything, and they got very stuck and left in some very difficult negotiations. They wasted a huge amount of money. They invested a huge amount of money in legal fees in trying to unpick a mess that was completely of their own making. So my strong advice would be, do go and consult a lawyer if you're planning to have a shareholders agreement in place. Otherwise, you're almost better off just having articles if it's a very simple arrangement. That's what
Thank you very much. And I think now we've got one more. Richard, I believe, last but not least.
Yeah. So my do would be to make sure you get proper financial controls and reporting mechanisms in place from the outset. I've known a number of startups get themselves in a proper mess in terms of their accounting records. Obviously, investors look at those in making decisions, so get those sorted out very early. And my don't would be pretty much the same as Andrew said, which is don't use documents, recycled documents, which you found on the internet or something similar, because they never do what you think they do, and you're not saving any money because you'll just be spending money on lawyers later.
Well, that is some amazing advice. Thank you very much to all four of you. I think now it's time to go on to some questions. We are now only 39 minutes away from wrapping this up. So for those of you that are here on the Microsoft Teams call, all you have to do is drop your question in the chat. We'll then give you the mic and you can ask the lawyers. The idea is that we're here to help founders with whatever questions you may have in terms of navigating that legal minefield that helps you take your startup from, well, your company from startup to scale up, really. And the idea is that, unfortunately, the two fields that most startups and founders that I meet totally botch up, and that includes yours truly, is legal and finances. Unless you come from a legal background, most of the founders I've been a co-founder with or I've helped, and most of them, mind you, actually, I think are better than I am, but they have not got a clue as to what's next. So we're doing this with four amazing lawyers who've helped founders like yourselves and myself, and they're doing it for free. All you have to do is drop your question with anything to do with the legal side of things in the chat. We'll then give you the mic and you can ask the team. If, however, your question is not on the legal side of things, please save them for the other events we run. Monday's talent, Tuesday's product and tech, Wednesday's growth, Thursday's fundraising, second Friday of each month, which is today, that's UK law, third Friday of each month, which is next week, that's UK finances. They're all from 12 to 1 p.m. UK time, and you can RSVP and register to any of them via our website, startuptoscaleup.club. For those of you, because I can see my laptop pinging, for those of you that are on the live stream, so that's LinkedIn, YouTube, Facebook, or Instagram, we are unable to monitor your questions live. So please do join us here on Microsoft Teams. It's audio only, and it's quite easy to get to us simply via our website, startuptoscaleup.club, and find today's session, which is Startup Legal Q&A 06. You then click join, quick registration gets you a link to your email, and through that link you can join us via any platform or device. And again, if I can ask the panelists to keep muted unless they're speaking, please, because it's creating a bit of an echo on the live streams, I'm told. So now what I'm going to do is we'll go on to the first question. This was sent in to us, so the panelists can read that in the chat if you'd like. So this is an agri-tech startup in Kent. It's a family business, and he says, I'm the sole founder of an agri-tech startup, and an investor has recently expressed interest in buying some of my shares. However, other investors are strongly opposed to this, believing it will dilute their control. What are my obligations to existing investors in this situation, and how can I ensure I comply with the company's shareholder agreements whilst trying to sell my shares? Now, this will be easy to limit lawyers to only speaking up to a minute, but I'm going to attempt it. So again, Ishita, since you've been here before, if you don't mind, you can go first this time, and then I'll switch it a little bit. So Ishita, and then Richard, then Andrew, and then Nigel, please.
Sure. Great question. So before I answer this, I just want to help distinguish between transfer of shares and issuing shares. Now, since you mentioned that you're the sole founder and you've got an interest in someone buying your shares, so if you transfer your shares, you are not going to dilute other shareholders, as in other investors, because you will be transferring your shares, not issuing new ones. So their equity or their percentage stake in the company remains the same. It's your percentage stake that is going to get diluted, in a sense, like you get, obviously bought out. The other one is like there are statutory preemption rights, which is essentially a right of first refusal, which is already something that the Companies Act kind of provides for. I'm not sure what's there in your company shareholders agreement, but you need to check if there are any in right of first refusals that apply, which essentially means that you have to first, if you're selling your shares to a third party, you have to offer those shares to the existing shareholders first. And if they are okay to buy it at that price, then fine. If not, then you can transfer it to the third party. So, you basically have to check what clauses or transfer restrictions there are in your shareholders agreement. Yeah, that's it. Thank you.
Thanks, Ishita. Just to add to that, you may well have provisions within your articles of association, which deal with preemption on transfer. So that is how you comply, is by checking what your shareholder agreement and what your articles say, and provided you comply with those terms, then either your shares will be bought by existing investors, or you can sell those to a third party. I think one crucial point is a lot of preemption clauses in articles state that once you give a transfer notice, it's irrevocable. So you need to be quite careful about that, whether your desire is to sell the shares or to bring this third party in. That's it from me.
I think it was Andrew and then Nigel.
Oh, sorry, I thought I was last. Okay, thanks. I think, I agree with what's covered. I think without wanting to repeat too much, but I think that the key thing is to check your shareholders agreement and articles of association to understand what hoops you may need to comply with on those transfer restrictions. Sometimes the shareholder agreement or articles will actually have a general prohibition on founders being able to transfer shares, for example, with an investor majority consent. You may or may not have that in your case, but that's certainly one to check. And then there's the right of first refusal, as you say, under the shareholders agreement, or more typically under the articles. The statutory preemption regime is really in relation to new issuances shares rather than transfers. So I'd only expect that ROFA, right of first refusal on transfers, to be contained within the articles, if any. And then there's also one other restriction just to keep in mind, is something called co-sale as well. So if you as a founder are looking to sell some of your equity, in addition to that ROFA we've talked about, there can be a requirement when selling to then allow existing investors to co-sell, come along basically with you on a proportionate basis with that sale. So that's the other restriction. Final point, I guess, is also worth checking in your investment documents whether there are any permitted transfers that you're able to use, which would potentially circumvent round any right of first refusal provisions as well. So sometimes, for example, transfers with board, maybe plus an investor direct consent, for example, can apply. So that could help facilitate that transfer. Just at a very practical level, though, taking a step back from the pure legals, I think it would be good for you to probably explore with the existing investors what their concerns are, because as Ishita mentioned, as it's a transfer, there is no direct dilution to their equity position. Now, they may be nervous about who the profile of this investor is. They may also not love the fact that you as a founder are selling down part of your equity as well. So trying to just understand the dynamics behind why they have those concerns, I think would probably help. Thank you.
Thank you, Andrew. Last but not least, Nigel, please.
I don't think I've got a huge amount to add to that. I think my colleagues have said everything you need to say on the subject. Firstly, this is a transfer. The person's asking about a transfer, not an issue, not issuance. So the statutory issuance provisions don't apply. So you need to see what's in the documentation. There's no statutory transfer provisions in the Companies Act, so it's just purely whether there's something in the articles or the shareholders agreement to prevent it, or any regime around it. I'm not going to say anything more than that. I think my colleagues have said plenty here.
Thank you very much, Nigel and team. And by the way, if you feel you haven't got anything to add, don't worry about just filling the void. It's totally fine to say, I'll pass on. So that is totally cool. We'll go on to the next question. Coffee, are you able to talk? I've given you the mic. Can you hear us? Coffee, can you hear us? You asked the
Yes,
question
okay.
in the chat, and you can.
Yes,
Perfect.
I can hear you. Yeah.
Introduce yourself, please, Coffee, and
Yeah,
then far away with your question. And by the way, the others can please mute because it creates an echo. And just before you go ahead, Coffee, a couple of things that are worth reminding everybody again. I think I mentioned it at the beginning. One, this has been recorded, and two, whatever we say here, it's based on the opinions of our experience and background, and shouldn't be taken as legal advice. Carry on, Coffee.
Okay. Yeah. Hi, my name is Kofi Fano. I've been working on an app. It's a fun and gamified app to learn African languages. So I use an AI platform to create the wireframe of the app already. So I've been looking for a company like a developer that I'll be working with, to develop the full app. So I find a company that's quite interested in working with me, and I drafted the NDA using an AI. Now they came up with some issues. They said there's few concerns that they have with the non-competition clause that I put in. The liquidated damages, I put like a £50,000 penalty on it. And for the intellectual property assignment, so I asked that I have the full control of the IPs, and they come up as well with the scope of confidential information. So I asked them if they can draft their own one that will be beneficial for the both of us, and then send me a copy, then I can read and see. So my question is, do you have like a standard NDA that I can use, to compare, to make sure that, I'm not the one losing anything, I'm not.
I hear.
Yeah.
Thank you very much for that, Coffee. Coffee, can I quickly ask you, one,
Yeah.
have you already incorporated?
No, not yet. No.
No, not yet. Will there be any IP or trademark or anything like that you're going for at this moment in time? Or is this a simple app to gamify
It's just a
learning
simple
a
app.
language?
It's just a simple app.
And where are these people? Where are these people based, Coffee?
So they have the headquarters is in Hong Kong, but they have an office in London. And
okay, so they also have an entity in London. That means it's
yes,
within UK law.
So the
Okay,
first
that's
NDA
good.
that they send me, they want to use the Hong Kong law. So I refuse it. I changed it, and I send it. I said no, I need that to be
You
based
asked
on
for a
UK law.
Okay.
Exactly. Yeah.
Now you said they had some concerns about what was it? The first one?
Yeah. So the first one is no competition clause. I put 24. I put 24-month restriction on developing competing application. So they said 24 months is too long. It should be between 6 and 12 months.
Okay. And what was the other one?
The second one is liquidating damages. I put £50,000 penalty for any unauthorized disclosure. And they said 50,000 is too much.
How much are you paying them? How much is this job worth?
No, so that's the thing. So I'm not paying anything. So we'll be working based on equity.
I see. Okay.
Yeah.
All right. Okay, that's a good point. Thank you very much for that. Okay, how about we start this with Andrew, then Nigel, then Richard, then Ishita, please. Let's try and keep it to a minute each, please, team.
Thanks, Coffee, for the question and context as well. I think just talking about the specific points that they've sort of pushed back on in inverted commas. I can sort of see where they're coming from to an extent. I mean, it sounds like they're providing the service, and they may get some equity if they develop whatever on the
Yes.
app side that they do, which is understandable. I guess just going to Anton's point there when he was asking about what the value is, just I think you should probably commercially think about what do you think the value of that equity is, in a sense, to consider whether that liquidated damages clause is proportionate. So that's just something to think about from a commercial perspective, really. Any kind of confidentiality agreement, I would say that including that liquidated damages concept in there is probably on the slightly more aggressive side, I would say, in the first place. I'm not saying that it's a bad thing to have from your perspective, because it's notoriously difficult to prove a breach and loss, etc. So having something like that in there is potentially useful, but I've seen many confidentiality agreements which wouldn't have that in there. And also you have to be careful that it's not seen as a penalty, because under English law anyway, that can often be deemed as a void provision. So it's quite you've got to be a little careful about how you craft it. On the non-compete, again, depending on what they are, if they do a load of other stuff and they're not exclusive to you guys, I can see why they'd be quite sort of wary about signing up to really any kind of non-compete at all. So even if you can get something there, even if it's on a shorter period, that would probably be a pretty good result from your perspective. And then on the IP thing, I think it is really important to make sure that whatever IP is developed for your project absolutely sits neatly within your business, because there's the value, even if it's not like a deep tech type arrangement. Nonetheless, you need to make sure that your business is absolutely within. And then in terms, so I'm probably going over a minute, but template wise, I think every law firm in the land probably has a confidentiality agreement that they could put together that that's on a form or whatever. So yeah, if you need separate advice, obviously happy to chat offline. That's about it. I'll leave the other guys to cover anything else. Thanks.
Okay, thank you.
No worries.
Thanks, Andrew. I think it was Nigel, then Richard, then Ishita.
Yeah, I think Andrew's covered most of the points, to be honest. I would just say non-compete is unusual in confidentiality agreement. You can have it, but it's unusual. So I think the danger of getting forms of AI is that they are not tailored to any real life situation. They are just standards, and in fact, if anything, that is not even a standard. It's a very aggressive position. I don't think liquidated damage is really aggressive, really unusual. I'd never agree to it if I was advising a client. So I think you've got a very non-standard. You've got a very non-standard NDA there, and you're going to have to push back.
Thank you very much, Nigel. Richard, and then Ishita, please.
Yeah, sounds to me like coffee. Like actually, an NDA isn't really what you need here, but you need some sort of formal development agreement between you and the developer, and that will deal with all of these issues, and that will encapsulate confidentiality, IP, etc. And the other thing is, I think crucially, you need legal advice here. You're dealing with some complex subjects, and what you don't want is to be handing over your baby and then nothing. So I would urge you to seek legal advice.
Okay. All right. Thank you.
Thank you very much. And last but not least, Ishita, please.
Hi, Coffee. Great question. I think Andrew, Nigel, and Richard have covered everything, but just a few points from my side. Because you're going to be developing a lot of IP, and this is not just an idea, like Richard said, you will need maybe an additional document with these developers just to cover, all the intellectual property. Where does it lie? Are they able to, transfer, which means assign all of those rights in it when they develop it to yourselves? And also, are you going to hold that in your personal capacity, or are you going to set up an entity in the UK or wherever you're based? So it's important. And what would be the governing law? Will it be UK? Will it be where they are based? UK law. Okay.
UK law,
so my recommendation would be, do not use a template right? Because you need to customize that, a template to your circumstances. And if there are complexities regarding the app and the kind of intellectual property you're creating, if you're using graphics, videos, etc., and this is a gaming app, so I'm sure there'll be loads of that. So yeah, you need to kind of get proper advice. Yeah, we're happy to advise you offline. You can contact me on LinkedIn, and yeah, we can help you get the right paperwork. Yeah.
Okay. Perfect. All right.
Thank you very much. And no, you're welcome, Coffee. And just before you go, Coffee, I just want to pose this quick question to the team, because my view here would be that it would probably best for you to actually incorporate a company and have all of these engagements through that LTD rather than through yourself. I don't know what the lawyers think. Just a yes or a no would suffice. Yep.
Yeah,
I see some thumbs up.
Yes.
Yes, literally incorporate. And I agree with Richard's point about you probably want a developer's agreement as well. And the other thing, say, if you have a developer's agreement, then you've got much more purchase in terms of enforcing non-competes, because you're giving him some more in, from your side in terms of you're giving shares.
Okay.
Totally agree. And by the way, one say, go on.
Yeah. So my main concern was if I spoke to them about my ideas, because I've already I've drafted the the wireframe and everything.
So you're worried they'll steal your idea from the beginning before you even get into agreement.
Exactly.
Okay.
Yeah.
Here's my view, Coffee. And again, this is not legal advice. This is from experience.
Okay.
In my experience, unless you have some heavy IP, like, I don't know, some scientific stuff or whatever else, it doesn't matter, because here's what happens. Those people that can steal your idea, they haven't got the time because they've got better things to do. Those people that have got the time, they haven't got the cojones to steal your idea. So that is the last of your worries. Again, unless it's some scientific stuff or some deep tech stuff, and I get it, or you've managed to, I don't know, come up with a solution for cancer. Most of the other stuff, it's really irrelevant. And guess what? No matter what NDA you have, they can still find ways, if people want to, especially a company that has multiple offices throughout the world, they can find ways to get out of it. So my advice for now, have a standard NDA, nothing fancy, and then all these other things that you mentioned, then maybe go to a lawyer or get them to give you their agreement, and you go with that agreement to a lawyer and you say, what do you think of this? That would be my go-to, if that helps, Coffee.
Okay, perfect. All right. Okay. Thank you.
Best of luck, and do feel free to join us again. Would love to hear on your progress, Coffee. And also, if you have questions on other matters, we run quite a few events, so just that's for you and the others here, by the way. A reminder, on Mondays we help with talent, on Tuesdays product and tech, on Wednesdays growth, on Thursdays fundraising. Second Friday of each month, as you can all see today, it's legal, and third Friday of each month it's finances. They're all from 12 to 1 p.m. UK time. You can RSVP via via our website, startuptoscaleup.club, to any of the future events. By the way, when you're there, you may also want to join our WhatsApp community. Top and bottom of our site, there's an icon for our WhatsApp community. We've got groups of founders, investors, and operators that you can join there. Quick reminder, by the way, to those of you on the live streams, we are unable to monitor your questions, whether you are on LinkedIn, YouTube, Facebook, or Instagram. And by the way, please, team, remember to mute yourselves if you're not talking. So if you do want to ask our panelists anything, you'll have to join us here on Microsoft Teams. Quickest way to do that is to go to our website, startuptoscaleup.club. You click on today's session, which is Startup Q&A Startup Legal Q&A, I'm sorry, 06. You click join. It's a quick registration. That will get you a link to your email, and through that link, you can join us here. And we're taking questions for the next 15 minutes on anything to do with law. And since Nigel is not muting, I'm going to get Nigel to answer the question first. So this is about a blockchain startup co-founder. They're based in West Yorkshire, and they say our blockchain startup in Wakefield, West Yorkshire, was advised by our previous lawyer that we did not need to register with the FCA since we won't be trading in the UK, which has led to potential regulatory violations. Given that the FCA's stance on crypto assets seems to have tightened recently, how can we mitigate the penalties from potential non-compliance to date? And what legal actions can we take against a lawyer for providing incorrect advice? Additionally, can we recover any damages for the harm caused by this oversight? So 2 things quickly. I see Divine has put a question in the chat. Thank you for all your caps, Divine. Unfortunately, not being in the UK, we're unable to give any opinions on this matter, but thank you very much for joining us though. If anybody else would like to ask any questions, just drop them in the chat and I'll give you the mic. So maybe on this, we can start with Nigel, then we'll go on to Ishita, and then Richard, and last but not least, Andrew. And please, again, if you're not talking, team, keep your mic off because it does create quite a bit of an echo. And let's try to keep it to about a minute each. Take it away, Nigel.
Okay. Well, this is kind of my home territory, blockchain and regulation. So you mentioned the word register rather than authorization. So there are 2 different regimes in the UK at the moment for crypto. One is, well, effectively there's only really one regime. The main regime at the moment is a registration regime if you are for money laundering, if you are either acting as a if you're either trading in crypto assets or you're operating crypto wallets. I don't know obviously we don't know enough context here when it says we won't be trading in the UK, what this actually means. But I've certainly worked with clients who have applied to register with the FCA as for money laundering purposes, and some clients get turned down and some clients are accepted. There is potentially a lot more regulation coming around for crypto assets in the UK, and the ultimate aim is for crypto to be treated like mainstream financial services assets, like equities or debt, etc. To some degree, that's already the case, because if you have a crypto asset which has the characteristics of a what the FCA would call an investment, then that you would need your activities would need to be authorized, and I say authorized rather than registered, because they are 2 different things. In terms of your dealing with this lawyer who's given you previous advice, this is very, very specific. I'd be very happy to take this offline and talk to you about it, because it depends completely on the facts. It depends on what activities you've actually been doing, what the FCA have said to you, and in terms of what legal actions you can take against the lawyer, again, that's completely dependent on the facts of what the advice was. Was this advice suitably caveated? What did the lawyer actually say, and what actually happened? So I can't advise directly on that without actually knowing more of the facts. But anyway, it is an area I deal a lot with. I deal a lot with the regulation of crypto assets. So I'm happy to. There's an awful lot more one can say about the subject, but I need to know more information.
Perfect. If anybody wants to, well, not anybody, but the person that sent the question, if you'd like to reach out to Nigel, please do so. Ishita?
Yeah. Hi, guys. This is outside my area of expertise, so I'm going to leave it to my other co-panelists to answer this. Thank you.
Thank you very much. And Nigel, mic off, please, buddy.
Beg your pardon, somebody.
Yeah, go on. Sorry. I can't remember who was next, but
It's Richard here. Absolutely nothing to add to what Nigel said, because what Nigel said was spot on.
Yeah.
Okay, you need to wait for 10 minutes. I'm sorry, because I'm doing the this thing. I'm really sorry. I'm really sorry because I was talking to the anaesthetist, but carry on.
No worries. I don't have really much to add either. I think Nigel has obviously got some good experience there. The only general thing I'd make is that the world of crypto has obviously been developing significantly, and some of it is policy related as well, and there are lots of grey areas there as well. So I think there is an element of an evolution of that industry. So I think you just need to keep that in mind in the context of what's gone on in your case. Thank you.
Okay, I think that's everybody. Is that right? I think so. Okay, sorry about that. I was just trying to speak to the nurse and the anaesthetist. Okay, I think we've got time for one more question. So let me just check. We had another one just here, and I will share that with everyone. And I guess we can. Okay, this is an interesting one, but similar to Coffee's question, although this is different. But I'll share that in the chat with the panelists, but I'll read it then out loud for those of you that are on the live streams, and so that you can also hear it. So where's the question? Fintech startup in Lincolnshire. The problem they have is managing IP rights related to blockchain technology and smart contracts. So the question she sends is, our fintech startup in Brigg, Lincolnshire is developing a blockchain-based platform with integrated smart contracts for secure transactions. We're struggling with how to manage the intellectual property rights surrounding blockchain codes and smart contracts. Given the open source nature of much of the blockchain ecosystem, how can we ensure that our proprietary technology is protected while still being compatible with the open source framework? Jesus. Should we file for patents, or is there another way to safeguard our technology and ensure we maintain a competitive edge in the marketplace? All right, so for this one, we can start with Richard, then Ishita, then Andrew, and last but not least, Nigel, please. Let's try and keep it to a minute each if we can, please, Tim.
Right. I have a colleague who specialises in intellectual property, and I most definitely do not. So I am rather.
That's cool. We can go on next.
I just think move on from me.
Good one. Thank you very much for that, Ishita.
Yeah, this is quite complex. I mean, obviously we'll have to evaluate this properly, but off the bat, I think you could file for patents, but again, it has to qualify for the novelty and other qualifications that you need for for something to qualify as a patent. But other than that, maybe ensuring you have strong NDAs and well-drafted IP agreements. Yeah, we'll just have to evaluate this more at length, yeah, that's it.
Hi, Andrew here. Yeah, I don't have much to add there. I think, to be honest, I think that it may be difficult to start filing for patents, as Ishita mentioned, if it doesn't qualify within that. So much of this is about managing it from a sort of trade secret perspective and having robust confidentiality arrangements, etc. So keeping things a close lid on any of that code that you're developing. Thank you.
Okay, I'll just add a couple of thoughts. So, I mean, the problem with open source is it is, by its nature, open to the public, and anybody who wants to, it's the collaborative nature of the blockchain community is that people post open source software, and then it's up to other people to play around with it. You can turn open source software into original software if there's a sufficient amount of difference between where you start and where you finish for it to be your own original work, and that is how a lot of blockchain firms do work. And so it's really you need somebody who is an expert in patent, who have done blockchain type patents. If you need a recommendation, I can put you in touch with people we work with, because again, patents are such a specialized area. It's not something that mainstream law firms do. You'd actually need a patent attorney.
Here, thank you very much. Now, we've only got 5 minutes to go, so we'll try and answer this last question quicker perhaps than we have so far, if that's okay, team. So this is about contractor liability negligence, and she says our company hired a contractor to develop a critical piece of software. Unfortunately, due to negligence on their part, the product has failed and we're facing major delays. What is our legal duty of care as an employer to ensure that the contractor performs their duties with reasonable care, and can we hold them accountable for the failure of delivery? Sorry, for the failure in delivery. Perhaps we can start with Ishita, Andrew, Nigel, and then Richard, please.
Sure. I think as the hiring company, you do not owe a legal duty of care to the contractor in the same way that you would to an employee, but the contractor owes your company a duty to perform their work with reasonable skill and care. I think you should review the contract terms, like especially clauses around warranties, indemnities, limitation of liability, etc., and gather evidence of failure. So, if your contract is, say, silent on key points like these, you may still rely on something called implied terms, that the services should have been provided with reasonable skill and care. But yeah, I mean, you probably can claim damages or specific performance, depending on the circumstances. But I would suggest get legal advice on this. Like, this should be discussed at length, and then you can probably, then the lawyer could suggest, the next course of action. But yeah, I mean, the contractor does owe your company a duty to perform the work with reasonable skill and care. Yeah, thank you.
Thank you very much. Yes, Andrew.
Thanks. Yeah, I agree with what is just said in terms of analysis. I think important to look at the relevant commercial contract to understand what obligations, both from an express perspective and also implied perspective, that the relevant contractor had. Is clear. Clearly, it sounds as if they haven't delivered what they should have done. And I think the question for you also is, I don't know how the contractors being remunerated, compensated, whether it's just a cash payment or if it's equity again, for example. So obviously, if it's any form of equity, you'd want to make sure that they don't receive that equity or it gets clawed back in some shape or form. If it's in the form
It looks
of
like a
cash,
payment. Based on the question, it looks like a payment. I'm assuming they would have mentioned equity, but I hear you.
Yeah. No, yeah, okay, no, fair enough. And if it is payment, whether it's all been paid already or whether you can withhold a certain amount, ultimately, there could be a damages claim if you don't feel that that's been properly done and or additional harm has been created. But you need to be able to sort of prove foreseeable loss, etc., around that. The other thing as well is that it may be also that you want to just terminate the contract and move on and get someone else in who's going to do a better job as well. And so if there's an ability to be able to immediately terminate that agreement and move on, summary dismissal, that would be also helpful from your perspective. Thank you.
Thank you very much. And I think then we've got Nigel and last Richard, right? The other way around, whichever of you gentlemen.
I don't have a huge amount to add to what my fellow lawyers have said already. I mean, it really comes down to what's in the contract.
Mm-hmm.
And then looking at implied terms if you have to. Sorry.
Yeah, I've got nothing to add to that.
Perfect. Thank you very much. Now, normally we have some parting words. I'm really sorry. I've got two nurses and an anesthesian or whatever they're called waiting outside the door. So I'm going to have to wrap this up. I'm going into an operation in half an hour. But thank you very much, everyone. I really appreciate your time. And hopefully you'll be able to join us next time. In the meantime, do join our WhatsApp community. We've got groups of founders, investors, and operators. You can do that via our site, startup2scaleup.club. Otherwise, we'll see you in the next few sessions. In the meantime, please do follow Ishita, Richard, Nigel, and Andrew. They've got their LinkedIn URLs here in the chat. follow them there and reach out to them if you need to otherwise. But have a great weekend and God bless you all. Bye bye for now.
Bye.